Hi, everyone. Harry here to talk about one more decision against the administration in an Alien Enemy Act case where they are trying to remove someone who is here with an entitlement, an order saying she can stay. But they say that the administration does is overridden because she is a member of Tren de Aragua. How do we know that, you may ask? And it's basically looks to be from the opinion granting habeas corpus to the petitioner who they want detainee, who goes by the initials MAPS or MAPS. It's those tattoos. They found the tattoos. They think she's a member of Tren de Aragua, and she has now brought a habeas corpus motion. And Judge Briones in the Western District of Texas in El Paso, where she is being held, has granted it, not so as to release her, but so as to make sure that she has the ability, including 30 days notice, to bring her opposition. As with all these things, there are two kinds of issues involved. One is just the factual issue. Is she or isn't she part of Tren de Aragua? And at least what it looks like is the administration jumped to that conclusion based largely on these tattoos. Recall seeing Trump display a picture with those in the case of Abrego Garcia that didn't even turn out to be real. But it seems pretty tenuous to jump from tattoos to membership in what the administration says, is this really a bunch of desperados and drug dealers who are plaguing the country? Anyway, she says she's not, but there's also the question of the interpretation of the Alien Enemies Act, right? And this is the question of, is there, well, we know there's not a war, but is there the equivalent, an incursion by a foreign country? It's always seemed to me, no court has ruled on it conclusively, but it's always seemed to me a very dubious proposition. But the idea is that either the administration really hasn't specified yet, either members of Tren de Aragua themselves constitute a foreign country, go figure, or that they are working for Venezuela and Venezuela is the foreign country, also go figure. Now, the Supreme Court, you may wonder, why don't we just defer to what the president says? I've got a whole long YouTube today explaining the risk of that happening in the whole mess involving California. But here, the Supreme Court has said now twice that based on strong precedent that already existed, the interpretation of the statute here is for the courts. It's not for Trump to just say, and what basically would be this Alice in Wonderland assertion of, we are at the equivalent of a predatory incursion by a foreign country. That's a factual matter for the courts to determine. And based on that, the judge here said, your assertion of authority to go after her doesn't cut it. This is not a valid invocation of the Alien Enemies Act. Now, he does say there may be other sources of authority, and maybe you can come back under different immigration provisions of law that he identifies. But for this, no, you can't. The Alien Enemies Act doesn't fly. So he says, first, I have jurisdiction. The U.S., as always, tries to challenge that. Second, and importantly, he agreed, did the judge, to constitute a class for which the MAPS, the alien here, who has approval to stay based on she was found to have reasonable fears of being persecuted down there. The order, of course, that Trump and the administration are trying to enforce simply says all Venezuelan citizens 14 years of age or older who are members of Tren de Agua within the United States, we can just boom, get rid of. again. So there's the factual question, is she? And then there's the interpretation of the AEA. So on both of those, the judge rules against the administration and he certifies a class to challenge everything on habeas corpus, something that a few other courts have done, but is still not completely settled, at least in the Supreme Court. But for now, it is settled here in El Paso. And so what will now happen, she doesn't get out of jail. She rather gets to challenge her detention based on both a claim, I ain't a member of this group, Tren de Aragua, notwithstanding tattoos, and also this is not the circumstance that permits it to happen. If she can make those showings, she and potentially the class should have a writ issue that basically says you're out. They don't have the authority to hold you. But the court does say, and we are probably going to be seeing this here or in other settings, that there may be other ways for the administration to skin the cat and invoke other authorities. But at least here, this judge has joined what's now shaping up as a chorus of conclusions by district courts around the country, but not just district courts. That one, you get to challenge under by habeas corpus, as a matter of due process, whether or not you're a member of the group, and two, you get to challenge in the same way whether the authority invoked against you is sound or not. And so then it proceeds to exactly these challenges. But that principle has been upheld by the U.S. Supreme Court, and now another statement, a even more far-reaching statement by this court in El Paso, saying, holding, this is not a valid invocation of the AEA, and you have to let them challenge it, and you have to give them at least 30 days notice, and he lays out how it's going to work from there. So what comes next in this case? An actual litigation of the issue, but he has pretty well explained at least the faults with the AEA. She may also now try to say, I'm not a member of the group. And then there's the question of relief for the whole class. But we have yet another forceful statement that the U.S. has stumbled, and that it's unprecedented assertion under the AEA. Recall that statute's been used only 3 times: War of 1812, First World War, Second World War. Just doesn't fly here. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.